John, how are you? When are we getting an updated country?
See progress.
Is it?
It's been in progress.
Okay, all right. The last one was 2011.
That's right.
Yeah.
All right.
Thank you all. Please be seated. Good to go. All right, welcome back, everyone. We are on the record with 23SC188947. If we could start with the state and have counsel who'd be arguing today identify themselves for the record. And on the defense side, if you could just make sure that we have your client's presence waived, if that's what we're doing today. Mr. Wade.
Good afternoon, Judge. Argument will come from primarily Mr. Floyd, Mr. Wakeford,
Afternoon, Josh.
as well as Ms. Young, and Alex Burnick will be addressing the court briefly as well.
All right. And over on the defense side, do we have Mr. Sadow? Can you hear us loud and clear on Zoom today?
I can, Your Honor. Thank you and good afternoon. I'm here on behalf of President Trump along with Jennifer Little, and we waive President Trump's appearance.
And for Mr. Smith.
Yes, good afternoon, Your Honor. Amanda Clark Palmer for Mr. Smith. I'll be arguing, but I've got my colleagues Don Samuel and Kristen Nove with me, and Mr. Smith waives his presence at this hearing.
Thank you, Ms. Palmer. And for Mr. Cheeley.
Yes, Kristen Olowitz and Richard Rice for Robert Cheeley, and I will be arguing today as well. And he waives his presence here today.
All right. And for Mr. Shafer. Did we have anyone coming? Oh, there he is.
We waive this for Shafer.
All right. And just for the record, let me have you identify. Okay. All right. So the first thing we have up to bat would be continuing our arguments from the December 1st hearing. And what we had left was all things RICO. And I know the matter had been extensively briefed. So I think what the plan I had in mind was that we can have about at least 30 minutes to each side. And obviously you can use the time any way you'd like, but I think the most effective thing might be to respond to opposing counsel's argument and the court's persuasive authority from October. So with that, Ms. Palmer, floor is yours.
Mr. Olowitz is going to start. We're dividing it up this afternoon.
Okay.
And Your Honor, I have a PowerPoint if I could be allowed to share my screen.
Which computer is logged in for that we need to make? Sure. Which device needs to have the control?
See all of this.
All right. Have you requested the hosting?
I think so.
Judge, whose device is it?
This would be Mr. Nolowitz.
Judge, I don't see him logged in Zoom.
Olowitz.
It says it's Canolo. It's CANULE.
Okay, you're a co-host.
Thank you so much. Second, Your Honor. All right. All right, is that appearing on everybody's screen?
No, I don't. Are you sharing?
I thought it was. About 1 second. Okay, share screen.
Yeah, like you're.
Oh, thank you. Okay. All right. There we go. I think it's fine.
There's something.
All right. Okay to proceed, Your Honor?
You're muted now.
Give that a shot.
Your Honor.
Okay.
And again, I know that this argument has already been raised before Your Honor at the October hearing. And in reading the October hearing, one of the things that kind of came to mind is, and I know that this seems like it's fairly obvious, but the scope of RICO does not apply to the allegations in the indictment. And I want to start off with something that I think is fairly fundamental, but I think it kind of got lost at the last hearing. And that is that 1614-2 is a law. It is the law of this state. It was passed by both houses of the General Assembly. It was signed into law by the governor, and it is the law of this state. It is not a resolution. It is not a guideline. It is not a suggestion. It is something that the state has to deal with. And in particular, what the state has to deal with is the fact that 1614-2 scope limitation that is contained in subparagraph B cannot be ignored. Justice Peterson in the Harrison versus McAfee case explicitly said that unlike captions, codified preambles are part of the act and are appropriate to be read in pari materia with the rest of the act. And I cite numerous cases on this slide where the Court of Appeals and the Supreme Court have repeatedly said that when you enact something in a preamble or in a statement of intent, that has to be given meaning, and it has to be read with the rest of the statute. The courts have also said, and these are just cases from 2021 to 2023, and I think there's about 25 of them from the Supreme Court and the Court of Appeals. They say that they will not read out of a statute language that the General Assembly has decided to put in there. They are not going to ignore language that the General Assembly has put in there as mere surplusage. So there is going to have to be, the preambles mean something. It is the law, and we are going to have to deal with the language that is in there. Well, when we look at the law and we look at what's in 1614-2, and I'm going to go through several canons of construction. The first canon of construction is that we start with the plain language of the statute. And when the plain language of the statute presents an answer to the question, we can stop there. Here, what does the plain language of 1614-2b say? It says that it is not the intent of the General Assembly that isolated incidents of misdemeanor conduct or acts of civil disobedience be prosecuted under the chapter. Very, very clear. It is the intent of the General Assembly, however, that the chapter shall apply to an interrelated pattern of criminal activity motivated by or the effect of which is pecuniary gain or economic or physical threat or injury, period. At the October hearing, the state didn't deal with and explain what the words pecuniary gain, economic or physical threat or injury mean, and how those are imported to the rest of the statute. It did not deal with the plain language of the statute that it doesn't apply to acts of civil disobedience, and it has to. We have to deal with that language. And here, the General Assembly has expressly said that it is not going to apply, the RICO Act doesn't apply at all to acts of civil disobedience. And we have, in our prior briefing with regard to the First Amendment, we have shown and gone through in detail in the indictment every single allegation, every single thing that the state is saying was done wrong are all statements, political statements that are made around the 2022 presidential election and the vote counting thereof. All of those fall within the category of civil disobedience if that is read appropriately. More importantly,
Where do you find the definition of civil disobedience? It's not in the RICO statute itself, right?
no, it's not in the RICO statute. I think that it's,
So how should we define that?
I think it should be defined as a political statement that is in opposition to some stated position of the government. And here you have a stated position of the government that, you know, Joe Biden won the election, that the vote counting was correct, all of those things. And the people that are indicted here, and the state expressly says it in their introduction, we are going after them because they disagree. That's what they say. And so I think that civil disobedience can be read for that purpose. Moreover, when you look at what does the statute apply to, the statute only applies to economic, fiscal, or bodily harm. That's what it says. It's
So
the
what do we
plain-
do with the last sentence? That's the one
What's the last sentence?
liberally construed, and the
Okay.
focus is on the operative provisions.
I was going to get to that, but I'll get to it
And
right
that-
now.
I think that we wouldn't even be having this conversation but for that last
All right,
sentence.
this is an easy one. Hold on one second. Hold on one second. I apologize. Gotta get to my right slide. Okay, here it is. All right. The state, I kind of feel like it's the Princess Bride, where I don't think that the words that they're using mean what they think they mean. Penal statutes in Georgia, and RICO is in part a penal statute, are always strictly construed against the state. That is the rule at common law, and it is the rule in case law right now. It is strictly construed against the state and liberally applied against the accused. And I've got a couple case sites there. Now, your question, Judge, OCGA 1614-2B says, this chapter shall be liberally construed to affect the remedial purposes embodied in its operative provision. Okay. There are two components of the Georgia RICO Act. There is a criminal component to it, and there is a civil component to it. What does remedial purposes aim at? Remedial purposes, and I took remedies in college and law school, is aimed at a civil aspect of the case. And Georgia courts applying this statute have said that the remedial purposes of the Georgia RICO Act, and this is in the case that I have cited here, the tabletop case, is to provide compensation to private persons injured or aggrieved by reason of any RICO violation. The remedial purposes of the statute apply to the civil part of the statute. It is also well established in Georgia law since at least, 1921, that the remedial purposes of a statute relate only to civil remedies, and that the liberal construction direction in 1614-2B applies only to the civil remedies. So as to the civil components, the purpose being to compensate persons harmed under RICO, liberally apply. When it is a criminal, as it is here, sanction, penal sanctions, you go to strictly construed. That's what the case law says. And in fact, in the case that we have cited here, the Shearman case, it says the same statute, and that's my bracket, like RICO, may partake of each of these separate elements to such an extent as will render it penal in one part and remedial in the other. And I didn't, my presentation's already clogged up with a lot of words. It's fairly
I've already
busy.
gotten you off track, but let me keep doing that just to
Yeah.
keep you on your toes here. So have you ever seen a case applying RICO where they've made this distinction between civil and criminal?
It's right here, tabletop. And the other thing that I will say is, and that's the plain reading. And I don't go into all of the other cases. There are cases in 2023, I think I just cited one in here, that talk about the application and the definitions of remedial and penal. There are two different things. Remedial is civil, penal is criminal. And if we dig into it, and if Your Honor wants a very long brief with a ton of case citations, I can do it. But that is what it means. And the other thing that I will say is, even if remedial purposes were to apply here, remedial purposes don't mean that you ignore the plain language of the statute. It doesn't mean that just because if you had a remedial purpose, even for the purposes of civil liability, that you would go beyond the plain language of the statute, which says that this applies to financial harm, economic harm, or physical injury. And I think physical can either be bodily injury or injury to property, probably. But that is it. And if you look, Your Honor, at that is explicitly what the General Assembly says, and I think we can stop and end with the plain language of the statute. But what we can also see is that the RICO limitations are relatively unique. So when you look at the federal RICO statutes, they don't have those same limitations that Georgia puts in there. And we've done some research, and I think that really no other states do. North Carolina comes the closest. And in North Carolina, their statute, General Statute 75D2C, provides for, it is actually more like our old statute pre-1997. But the North Carolina courts interpreting that scope limitation have said that the plain language of the statute, coupled with legislative intent, clearly indicates that the scope of RICO is limited to cases where pecuniary gain is derived from organized unlawful activity prohibited under the statute. So a North Carolina statute dealing with the same type of statute that we have here has imposed those types of limitations to limit the scope of RICO. And if the plain language wasn't enough, we look at what else did the General Assembly do with RICO. I went through every single RICO activity that's listed. And every single racketeering activity that's in 1614.35A has to deal with either economic or fiscal harm, fiscal being money, obviously, physical harm, or both. And that slide shows where every single one of those predicate acts are dealing with that. What does that tell you? That tells you that the General Assembly really meant what it said in the preamble, and that it's going to apply to these types of things. So when we're reading the rest of the statute, we're saying, okay, that makes sense. That makes sense. The General Assembly has said it in the introduction, and then they've proved it out in the racketeering activities that they've put there, that those are the primary directions of those racketeering activities.
So when the state comes back and says, even if we accept that, one, it doesn't have to be explicitly alleged. You can just bring this up at a directed verdict 6 months later. Or two, we're going to be able to show that in the facts of this case.
I don't think that that's right. We are here on a demur. And in a demur, the state has to state in its indictment exactly what are all the elements, what are the facts here, and that the statute applies. And they haven't been able to do this. I also ran a search in the indictment. What do I not see anywhere in the indictment? There is not one allegation of harm to a body or to property. Not one. There is not one. If you type in the word money, if you type in the word fiscal, If you type in the word economic, it's not in there. And it's not in there because the state's entire indictment is explicitly premised. Again, go back to their introduction, go back to their definitions of enterprise. It is explicitly premised upon their disagreement with the political speech of these people and the political activities that they undertook, none of which allege any type of economic or physical harm. At the last hearing in October, the state stood up and said, well, maybe Donald Trump got money from being a president. No, maybe Ruby Freeman was physically threatened. And my response to that is when we look at the case law, indictments don't get helped by argument or briefing. Indictments stand or fall on what is alleged in the indictment. And the things that were argued at that last hearing, and
They're not in there, but why is this, what's your authority that says this is an essential element that has to be alleged?
I don't think that it's an essential element, but just like statutes of limitation, jurisdiction, other types of things, the limitations of the statute are on its face in there. And the state is going to have to say in its indictment for RICO to apply that this is economic, fiscal, or bodily injury. It's got to plead that, and it pled nowhere in there. And the state is simply saying, listen, I want you, judge, I want the courts to just don't believe your lying eyes, cover up what it says in the statute, don't look at what we've specifically pled in the indictment, and maybe coulda, shoulda, woulda down the road, we can prove something. That's not what their burden is in an indictment. Their burden is to state all of the material facts that show the complaint, is state all of the elements. And if they can't show that this act applies, and they haven't shown that this act applies, then it is due to be dismissed. And I think that this is important because not only are there, do the plain language and everything else that I've just told you support that argument, but you then get to look at the statutory history. Georgia courts have repeatedly said that we are going to look at statutory history. Statutory history is not legislative history. Statutory history is when we look at the changes in the statute, and when we look at the changes in the statute, we see that the General Assembly has made a considered choice to do something. And what do we know that happened in 1997? In 1997, there was a case, that Savage case, that looked like it was competing with a couple of other courts of appeals cases. And the General Assembly came in and said, listen, we want to both expand and constrict what RICO is looking at. We are going to expand it by adding economic or physical threat. That's going to be some additional words that we're going to put in there. So they expand the scope to that. But then in order to get it through, just like any legislative process, you got to get a lot of people to agree. They said, we want to make sure RICO doesn't go too far. And so we're going to exclude civil disobedience. Had the General Assembly wanted to come in and said, listen, if you have a, I don't think they could do it constitutionally, but if they came in and said, listen, if you've got political speech, that falls under RICO. If you've got some other argument, the violation of Title 21, the election code, that falls under RICO. What did the General Assembly do? It didn't do either of those things because it didn't mean it. And here, you're not even dealing with a statute where you've got this, and then a catch-all phrase, or including but not limited to. This is just clear on its face, and it says it's these three things, that's it. And we know that the General Assembly in 1997 went through, again, this is why I harp on the fact that this is the law, is the General Assembly felt it was necessary to go in, both chambers, go through the process, go through committee hearings, get the governor to sign it, to make it a law of this state that this is what RICO is limited to, and the state doesn't even do that here. Moreover, when we're looking at these things, if the plain language and the statutory history are not enough, we apply the canon of constitutional doubt. And the canon of constitutional doubt will say, and I don't want to take up, I see you looking at the clock, I don't want to take up Ms. Clerk Palmer's time, but it says that if possible, that we can read the statute in a way that it's unconstitutional, then we really ought to read it a different way. I'm not going to go through all our First Amendment arguments, but clearly there is a problem here that if you read the statute in the way that the state wants, you will render it unconstitutional. And under the canons of constitutional doubt, it ought to be read the way that I'm saying. We've already gone through the strict construction and the limitations. We also look at legislative history. Georgia courts don't always look at this. Sometimes they do, sometimes they don't. We've cited the Gable case, and it talks about what Mike Hobbs had to say, what Senator Clay had to say, what two other people in the General Assembly had to say. And I'm pretty sure I know what Mike Bowers would say. And the only thing that's contrary to that is a meeting at a barbecue restaurant. If you take a look at what the legislative history is, then the legislative history is going to say that RICO only applies to what I'm saying. So you look at then the plain language, the doctrine of constitutional doubt, the statutory history, the application of strict construction to penal statutes, and then the available legislative history. All five of those things are in our benefit. And because all five of those things are in our benefit, then the RICO statute needs to be read in the manner in which I have suggested. And again, the only thing that the state has said, and I read very carefully the October hearing, is, well, just ignore it. And you can't ignore it. And Your Honor, because I'm running over, I'm going to stop. And I may get up and respond to Mr. Floyd if you'll allow me, but I'm going to allow Ms. Clerk Palmer to present her issues.
You want to go now? You want to respond?
Do
to
you
that now?
mind?
I don't have a strong preference.
Okay. If it's acceptable to counsel, Your Honor, I just
Okay.
soon respond to Mr. Nullis so that we don't
Sure.
Chris, you okay?
mush everything together, as it
All
were.
right. Floor yours, Mr. Floyd.
Thank you, Your Honor. I don't need it. Thank you. I don't need it. Okay, Your Honor, 1614-2, the provision that launched 1,000 demurs. The state does not and has never said ignore 1614-2 like it doesn't exist. That's just not true. Okay? 1614-2 exists. The question is, what, if anything, does it do in the context of this case? And the effort here is to turn it into a pleading requirement. That's the whole name of the game. It's not a pleading requirement. The Georgia courts have held over and over again it doesn't create a pleading requirement. Those rulings are binding. Cotton Inc., Shearson, Roe. Those are decisions of the Court of Appeals and of the Supreme Court. And they say you do not have to plead in accordance with this. You don't have to plead affirmatively that organized crime is involved. You don't have to plead affirmatively pecuniary gain, economic or physical threat or injury, etc. The corollary to that is you don't have to plead the negative either, which is it's not civil disobedience, etc. That's where we sit right now. Okay, that's the law. We're not starting on a blank slate here, right? And my friend, Mr. Nulowitz, he's emphasized certain things, but certain things didn't really get mentioned along the way. The United States Supreme Court, part of the argument is that you have to interpret it as he would have it to save the constitutionality of the statute. Okay? No, you don't. The United States Supreme Court looked at that question in Now versus Scheidler and said, no, there is no requirement of an economic harm or injury. That's not needed to, quote unquote, save the statute, right? Nor is there anything about the application of this statute in this case, in a First Amendment circumstance, that is required to, quote unquote, save the statute. let me stick to the economic or pecuniary gain or economic harm, et cetera. First of all, it's not, there's no indication that that's a proof burden on the state. But if it were a proof burden, it is not an allegation burden. And much of the game of demurs, as Your Honor has seen, is always let's turn the probata into the allegata. If it's something the state would have to prove at trial, then it must be alleged. The law is absolutely to the contrary. That is not the case. We do not have to plead all our evidence. We don't have to plead in anticipation of affirmative defenses. And these are affirmative defenses. They're not pleading requirements. No Georgia case says these are pleading requirements, right? The General Assembly hasn't even said they're affirmative defenses, and the General Assembly certainly knows how to do that. There is statute provision after provision after provision in the criminal code where the General Assembly says this is an affirmative defense. They did not do that here. They did not take 1614-4 and say, state, you must prove economic or physical harm or injury, et cetera. You must prove not civil disobedience. That's not in there.
So then what is the ultimate effect of that sentence of expressing the intent of the assembly? Is it just a suggestion, kind of a hope?
They are generally characterized as precatory words in statutory analysis, yes. And they may provide, in a close question, some guidance to Your Honor. I mean, that this is what we were thinking. This is why we did what we did. But it's utterly illusory to think that this covers all the circumstances of RICO. And this is both the blessing and the curse of provisions like this. There is a somewhat similar provision in the Organized Crime Control Act of 1970. RICO is Title IX, if I recall correctly, of that provision. And a great deal of ink has been spilled going through, it's often referred to as ACCA, the preamble to ACCA, and the same arguments, species, the siblings of these arguments. You must prove an organized crime nexus, rejected, okay? You must prove a racketeering injury because that's what Congress wanted, rejected, right? You must prove, et cetera, et cetera. I mean, the history of the United States Supreme Court decisions on RICO is defendants coming in and pointing to legislative history or the preamble and saying, here's a thing that also has to be in here because otherwise it quote unquote wouldn't make sense, but that's what Congress intended. And the Supreme Court has said no, and they've always said no on the basis that we look at the operative provision. It's not there. You know, I mean, when federal RICO was passed, there was endless discussion of organized crime and it's invading the United States economy, et cetera, et cetera. Okay, and when defendants said, you've got to plead this state, you've got to prove it, civil plaintiffs, you have to prove it, the court said no, because it's not in the definition of the offense, right?
And so the last sentence of the what your counsel was saying is that there's this division between criminal and civil.
Yes, no, there's not. And the case he cites doesn't say that, okay? And Georgia has never done that. And the problem is, what he's saying is, as a consequence of his interpretation, it's completely untenable because it means 1614-4 A, B, and C mean one thing in a civil case and another thing in a criminal case. That makes no sense.
Why is that untenable?
Because you've got to figure out what each word means, right?
So he points to remedial.
Yeah.
I guess they didn't have to include the word remedial. They could have just said effectuate the purposes.
Yes, but it's operative provisions. 1614-4 is an operative provision. The application of those operative provisions in both civil and criminal cases do have remedial impacts. For example, under Georgia RICO, there's a provision that expressly says a defendant who's convicted of a RICO violation is estopped from denying the facts of that violation in a subsequent forfeiture proceeding. I mean, these are integrated. It does flow through. And so a criminal conviction does have impact on remedial provisions down the road. And that's expressly in the statute. General Assembly knew exactly how to do that when they wanted to. But in contrast to the statements of intent, in looking at this, in the first sentence, the General Assembly declares its intent. Second sentence, its intent, not in its intent. Third sentence, is its intent. Last sentence, shall be construed. Not, it's our intent, our general sense, our suggestion, our recommendation, or please think about this, courts and prosecutors. It is shall, mandatory language. Only time shall is used in the provision. And that is the language that you looked at in your earlier ruling of October 17th. That is the language that the Court of Appeals has looked at as well. Pecuniary gain. The argument was made to you that after an exhaustive look through the statute, that every violation defined as racketeering activity either causes economic, physical, or bodily harm. That is manifestly not the case. Perjury, false statements, tampering with evidence, obstruction, forgery, destruction of evidence are all violations. None of them necessarily cause economic or physical harm. None of them, all of them are defined as acts of racketeering activity. Those are just the examples I could come up with off the top of my head. There's probably many more than twice that. It is simply not an accurate characterization of the statute. That is not how this statute was built. It was built long before 1997 when this was done. And there is no such structure. That's what they tried in Now versus Scheidler. And that actually goes back to a Second Circuit case called Ivich and another one called Bagarich, both of which imposed an economic motive requirement. Those were rejected by the United States Supreme Court. Why? They said, we're not having a seance here about legislative intent. We're looking at the operative provisions and it's not in there. Okay. And if this was a limitation, if this was a requirement, absolute requirement, as Mr. Nullis would have it, it would be in 1614-4A, and it is not. The presumption is here that somehow the state has to allege in the indictment exactly every economic impact, exactly every harm, exactly every bit of anxiety. Nothing says that. Nothing says that. Has the state alleged a circumstance where it could not do so? Has it precluded itself from doing that? Absolutely not. Nowhere do we say there's no economic harm, pecuniary injury, etc. Nowhere do we say this is civil disobedience and exercise of First Amendment. No, that's a characterization of the evidence that they say they will put forth at trial. That is not a pleading contest. We are not in the 17th century here. Economic harm. We allege data was stolen. We allege equipment was intruded into. That's economic harm. All right? That data has value. That data is defined by the relevant statute as property. Economic gain. Well, the name of the game, as I pointed out when we had earlier argument, was to make Mr. Trump president, even though he lost the election. That carries with it a lot of things. A very large salary, benefits, retirement benefits that are very substantial, the most prestigious residence in the world, and the most prestigious transportation in the world. In anyone's mind, that is economic gain.
And is the trio of cases around Sevchek in the 90s, is that really the last time this ever appeared in a Georgia case?
Cotton Inc. is a little more recent. Cotton Inc. is in the 2000s.
It's been 20-something years since anyone's tried this?
It's been a long time. They've pretty much given up on it. Perhaps the motivation here is more powerful. I don't know. No, this has been been essentially regarded as a discredited argument. Um, let me turn to civil disobedience for a moment. Mr. Cheeley tries to recharacterize things like his false statements regarding vote counting as an act of civil disobedience, right? First, again, as we've said before, 1614-2 doesn't modify the essential elements of a violation. It doesn't create them. But second, there is no basis to conclude that his conduct, for this court to determine as a matter of law, that his conduct was civil disobedience. And you've been offered none. They've just said it. It's just Dipsy Dixon. Okay, so that term, as you pointed out, Your Honor, is not defined by the statute. It's not defined by any other provision of RICO or any other Georgia statute. Pretty much leaves us looking to common parlance. Where does that take us? Well, the New Oxford American Dictionary calls it the refusal to comply with certain laws or to pay taxes and fines as a peaceful form of political protest, right? Other dictionaries use essentially the same definition. It is a fundamental concept of civil disobedience that the person engaging in the disobedient conduct acknowledge what they were doing, acknowledge they are violating the law. That's actually the point. And that they accept punishment for it. I looked at the Encyclopedia Britannica article on this. The civil disobedient, finding legitimate avenues of change blocked or non-existent, feels obligated by a higher extra-legal principle to break some specific law. Is because acts associated with civil disobedience are considered crimes, however, and known by actor and public alike to be punishable, that such acts serve as a protest. By submitting to punishment, the civil disobedient hopes to set a moral example that will provoke the majority or government into effecting meaningful political, social, or economic change. Cheeley did no such thing. We don't allege he did it. He can't introduce facts controverting our allegations in connection with a demur because it becomes a speaking demur and the court has to deny it. But Cheeley, one thing we know, Cheeley denies violating any law. Cheeley is not a civil disobedient. There's no reasonable interpretation of the term civil disobedience that could include soliciting public officers to violate their oaths, not the oath of the disobedient, somebody else, asking somebody else to commit a crime, making a false statement or writing, committing perjury. Okay, those are acts that Cheeley is charged with. Under no definition is that civil disobedience. And simply getting up and saying, I asked some questions about an election, that's not civil disobedience. Okay, and he says, he invokes the First Amendment again, but that's not what they're charged with. That's the problem. They're trying, they don't get to modify our indictment. They don't get to edit it, rewrite it, etc. They can go to trial and present facts if it's a legitimate defense, but that's it. Solicitation of somebody to violate their oath is not civil disobedience. Lying by making a false statement is not civil disobedience. Perjury is not civil disobedience. These things are deceptive. These things are immoral. It is not calling forth a higher moral principle. It is being sneaky and dishonest. As a co-conspirator, Cheeley is also responsible for the acts of his co-conspirators, all of them. Impersonating a public officer, forgery, filing false documents, influencing witnesses, computer theft, computer trespass, computer invasion of privacy, conspiracy to defraud the state, to deceive the state, acts involving theft. Under no reasonable interpretation is any of that civil disobedience. It doesn't become so simply because the defense would like to don a particular mantle. Most importantly, none of these defendants admit any of the crimes they committed, which puts them directly at odds with the fundamental premise of civil disobedience. as I said before, it's interesting. This has not been asserted as an affirmative defense. And I think that's quite conscious because the defendants know then they have to go to trial and have the burden of coming forward with evidence on that. Instead, they're trying to turn it into a sort of super affirmative defense by elevating it to a point that lets you, in essence, push an override button on the indictment. But again, and I mentioned this briefly at the beginning, when the General Assembly wants to create an affirmative defense, they know exactly how to do it. And I'll give you just a few examples. Article 3 of Title 16 consists entirely of affirmative defenses. 16810 creates the claim of right as an affirmative defense to theft offenses. 16620 and 21 create affirmative defenses to bigamy. And every one of these says it shall be an affirmative defense. False or fraudulent identification, 16994. 1611127, carrying a weapon in an unauthorized location. 1612141, abortion. 16132.4, transaction in controlled substances or marijuana within 1,000 feet of school property. In every one of those instances, the General Assembly thought under some limited circumstances, there should be an out. And they said what they meant, and they put it in the statute, and they said, you know, defendant, if you can establish this, you are not guilty. They did not do that here. I'm happy to answer any questions. I think I had one other point. The tabletop case that was cited as being a RICO case, it's not. That's, you know, when we've talked about this before, there are statutes out there. There's one in the Gang Act, a provision in the Gang Act, which is very similar to RICO. General Assembly didn't include it here. Basically says the court can examine whether the charge is consistent with legislative purpose. New York has a judicial override provision in its Organized Crime Control Act that specifically allows a judge to dismiss a case if they believe the prosecution is not consistent with the purpose of the statute. The General Assembly did not do that. They did not, in essence, cross the wires between the branches. These devices exist, but they are not here. They are not in this circumstance. And the defendants have not given you a way to logically apply the provisions as they would interpret them, which are manifestly incorrect. Let me be correct. To this case, what they want you to do is just make a sweeping statement that the defendants call certain conduct civil disobedience, therefore it is, therefore pleading requirement that's utterly undefined and utterly uncodified wipes out the indictment. That makes no sense. And quote unquote civil disobedience would now suddenly become a defense to almost every RICO case because almost everybody's going to say, I did it for a higher moral purpose. Normally that is no defense at all. Right? And the General Assembly knows how to enact an out like that, and they did not do that. And in fact, their final admonition is that this provision shall be liberally interpreted. The argument that is being made is one that's, the two arguments that are being made are ones that are intended not to liberally interpret to achieve remedial purposes, but to gut the statute. No Georgia court has done that. No Georgia court has suggested that that's appropriate. And the decisions that exist interpreting this provision do not leave that leeway. There is simply not room for that approach. They have gone exactly the opposite direction. And they were right in doing so. what they did was entirely consistent with what the United States Supreme Court has done with RICO. The find a requirement game, that is, find a requirement that's not in the operative provisions, apply it, and use that to dismiss a case, is something the U.S. Supreme Court has rejected over and over and over again. And it's important because it's a game that has no end once it begins. And it, in essence, amounts to rewriting the statute as the General Assembly enacted it. Because the guts of this statute are 1614-4. That's what tells us what a violation is and what a violation isn't. They want to change it. They want to add to it. They want to really add words to that provision. And not just words that would create a proof requirement, but words that create a pleading requirement. And so we now get into an endless game where the state would have to anticipate every possible defense and plead in anticipation of it. And according to the defendants, plead every fact it has in anticipation of that defense. There is no Georgia law that does that. And now is not the time to start. Thank you.
Thank you, Mr. Floyd.
Judge, I'm going to beg you for some more time from Mr. Clark Palmer.
Sure.
Just very quickly, the only thing that we are arguing here is in the four corners of the indictment. It doesn't state a RICO claim. It's not an affirmative defense. It's not anything else. We are within the four corners of that indictment, and do they or do they not? I've heard a lot of references to the United States Supreme Court. The federal RICO statute doesn't look like the Georgia RICO statute. The Georgia RICO statute is unique, and the General Assembly here has explicitly said what it is limited to. In no point in time in Mr. Floyd's remarks did I hear what does it mean to limit it to economic, fiscal, or bodily harm, because they don't have an answer. The other thing that he said, there seems to be some type of issue. Well, this hasn't come up in 20 years. No, it has not. Why? Because as they admitted in the last time that we were up here, this is a unique case. Prosecutors understand what RICO means. And they have taken the RICO statute, they have morphed it and twisted it and cajoled it into something that the General Assembly expressly said it does not apply to. And why hadn't we seen this come up in 20 years? Because nobody else has dared to do it. With regard to the three cases that Mr. Floyd referenced, Cotton versus Fildan, he says that there's no requirement in the statute to allege a nexus between organized crime and the economy is of no consequence. That's what Cotton said. What do we know from Ms. Clark Palmer's Kimbrough case? Yeah, you do. The Georgia Supreme Court has expressly said that you do have to do these things. Cotton, a civil case, Rehal, a civil case. And when you look at them in those cases, all of them are alleging economic harm, which was the statute at the time. The statute was changed even after Cotton. Cotton was dealing with the 1996 statute. The General Assembly changed it in 1997. And so at no point in time do those cases don't apply here. And when I'm listening to the argument by the state, they seem to think RICO's got this talismanic magic that it covers everything, and that when they say it, they can circle kick a defendant. No. You have specific limitations in the statute as to what it applies to. You've got enterprise. You've got all of these different things. You've got to have a listed predicate act, and it's got to be economic, fiscal, or physical harm. That's what the General Assembly said, and they've said it over and over again. And Justice Peterson said it, and the cases that I cite to you say it, that you've got to give that some effect, and the state has failed to do that at all here. With regard to the other numerous references to other courts, our courts have said that it does have meaning. Our statute is unique in the nation. And with regard to how the Supreme Court has taken issues and whether or not it has applied RICO to issues of protected constitutional First Amendment activity, I got a whole slide with lots of different cases, but it starts off with Alexander versus the United States, 509 U.S. 544, 555, 1993. The RICO statute does not criminalize constitutionally protected speech. And it can't. And what do the words, we get off on, you've got to, it's some type of throw in civil disobedience where I've got to be willing to go to jail. What the common definition is under Merriam-Webster, refusal to obey government demands or commands, to disagree with the government, forcing concessions of the government. When the statute was applied and you look at the law review articles and other things that surround it at the time of the statute, they're trying to make sure that abortion protesters, environmental protesters, people that are getting up and saying, listen, I disagree with you, that they're not going to jail. And in the 20 years, 25 years since this statute has been passed, that has not been applied in one case, one time, except for here. And why hasn't it? Because the statute doesn't apply. And I've given you 5 reasons: plain language, statutory construction, statutory history, strict construction. We didn't hear any differentiation, and you've got the cases and you've got the discussions about penal versus liberal. And on that, again, even liberally applied, you've got to give effect to the plain language in the statute, which they're just not conceding can happen. There's no explanation. And with regard to the indictment, you have to say, if the act is going to apply, you've got to say in the indictment itself, I'm not looking forward to trial, I'm not looking forward to proof. Somewhere in here, in its 4 corners, you've got to say that it applies to those things, and they don't. Thank you, Your Honor.
Your Honor, may I correct one statement?
Sure.
Yeah. Well, you asked me a question. I realized I gave you an incorrect answer.
Okay.
And it was whether this argument of economic or pecuniary harm as a requirement has come up in the last 20 years. When I answered you quickly and I'd forgotten, it was argued by the defense in the APS case. It was rejected. The argument was not raised on appeal, but that's less than 10 years ago.
But the order you're going to have on that is just at the trial level?
I mean, the only ruling was at the trial level.
Okay.
But
Had I been representing the teachers, I would have.
I'm going to push forward. Understood. All right, Ms. Ballmer, how much time do you need?
All right. Good afternoon, Your Honor. I did hear the court's instructions to say basically tell me something I haven't heard yet in the brief, so I will endeavor to do that. I do want to preface my argument by explaining to the court the reason we handled the argument in the way we did by kind of starting with the substantive counts and working our way back up to RICO was to show you the problems that we see with the underlying conduct that the state has alleged in this case. And the reason why we have all these weird crimes like conspiracy to commit solicitation of violation of an oath of office and things that we don't think fit into the substantive crimes is because this indictment is seeking to either criminalize constitutionally protected activity, or the counts don't provide us enough information to prepare our defense, like the solicitation of the violation of oath of office for the legislators, or perhaps the counts charge activity that might be a crime, but it's not a racketeering activity. Perhaps maybe it's something that would be found in the election code, a crime that would be found in the election code, but it's not a pattern of racketeering activity or a racketeering act as defined by our RICO statute. And so because the state is trying to shoehorn this conduct that doesn't fit into a RICO prosecution, you've got to dismiss this indictment. We think it demonstrates the fundamental flaw with their prosecution. So you know our arguments about the enterprise and that we think the indictment doesn't have limits on who could be part of the enterprise and doesn't appropriately define the enterprise. So I'm going to kind of truncate that part of my argument and skip to the next part of my argument, which is about the nexus between the activity in the indictment and the enterprise, because it's interrelated. And that's the part that I know you mentioned or the court mentioned in its order back in October denying the demurrer for the other defendants that the indictment did allege a sufficient nexus and that it did appropriately define the enterprise. But the order didn't provide a lot of detail or facts that the court had relied on. And so I'm going to present some other arguments and facts that I would ask the court to look at and reconsider. So yes, in our view, the failure to appropriately provide detail between the alleged criminal activity and the enterprise is a Kimbrough problem. It's not a general demurrer problem. We're not saying that you haven't alleged a crime, because count one does use the words that are in the RICO statute. We're saying you haven't given us sufficient.
So Kimbrough's nothing at all, right? That's the quote. Nothing at all was in Kimbrough.
Yeah. So what
We've got
Kimbrough
something
was,
here.
right? Kimbrough was count one is RICO, and then counts 2 through 50 or whatever are just substantive crimes themselves. They were all VGCSA crimes for the different people. And the Kimbrough Supreme Court opinion listed, here are some ways we can imagine these people could be associated with the enterprise. Maybe they're employees, maybe they're patients, maybe they're doctors, but the indictment doesn't tell us which one of those it is. So look at this indictment with an eye towards my client, Mr. Smith, same problem. He's mentioned 19 times in the indictment, okay? Every single time he's mentioned, it's in what I've called kind of like the caption of either the count or the substantive act, right? It said we're alleging that this person committed this crime on this date. Except for one, there is one act where it says he and Mr. Shafer encouraged other people to sign a document, okay? There's no information in the indictment about what Mr. Smith's connection to the enterprise is. Is he a lawyer for the campaign? Did he have some phone call or some email where he's communicating with somebody else who's alleged to be part of the enterprise? That's what we don't know. Okay, and this is why we think Boyle is so helpful to our argument. And I know the state says, yeah, but in Boyle, the defense lost. Okay, that's because, the defense was asking for a fairly specific jury instruction. But there is still some very helpful language from the majority opinion in Boyle, right? The Supreme Court did hold that the ongoing organization must have some sort of framework, whether formal or informal. And they said, we agree with petitioner that an association in fact enterprise must have a structure, that there are 3 structural features: purpose, relationships among those associated with the enterprise, and longevity sufficient to permit the associates to pursue the enterprise's purpose. And very helpfully, I think, the opinion says it's easy to envision a situation where people might engage in a pattern of racketeering activity but not establish the existence of a conspiracy. If several individuals independently and without coordination engage in a pattern of crimes like bribery or extortion, proof of these patterns would not be enough to show that the individuals were members of an enterprise. So I was trying to think of another analogy, and what came to mind was thinking about the protests around what we all call Cop City, right? There have been some people who have been arrested and charged with a RICO enterprise in that case. There's also been other people who have protested. They have the same goal as the people who want to stop Cop City. They've done it the same way. They've gone to demonstrations. Perhaps they've even committed crimes. Perhaps they've committed criminal trespass. Perhaps they've done those things at the same time as other people who are alleged to be in this RICO conspiracy. That doesn't mean that everybody who shows up to protest and to commit a criminal trespass to get to their goal of stopping that training center to be built is in a RICO conspiracy. So look at Mr. Smith in this indictment. The first time he comes up is in Act 23. But there's nowhere in the indictment where it explains, what is his relationship to those who are associated with the enterprise? At most, he is alleged to have committed certain acts either all by himself or at the same time as other people, but there's no allegation of how his acts are connected to the enterprise. That nexus is missing. And that's why count one cannot stand in this case. So let me go back. Now, another argument that I know we've heard from the state about conspiracy and some of the conduct that is alleged in this case is that this is a RICO conspiracy. And they've said a couple things. Number one, we don't have to prove we don't have to allege that 2 racketeering acts were committed because it's a conspiracy. Okay, but you do still have to give us enough information to prepare our defense under a special demurrer analysis, right? And we know that when we have compound crimes like conspiracy, and especially like RICO conspiracy, that the state does have to descend into the particulars and allege how the criminal objectives or goals of that compound crime were going to be reached. So one case that the court can look at for the proposition that a compound crime has to allege at least the elements of the underlying or predicate offense is a Howard versus the state, which is 252 Georgia Appeals 487 from 2001. That was a vehicular homicide case. Okay, so the defendant was complaining, well, you've charged me with vehicular homicide and you've alleged that the underlying traffic offense was reckless driving, but you did not allege one of the elements of reckless driving. Now, the defendant didn't succeed in Howard versus the state because the indictment alleged vehicular homicide with reckless driving being the traffic offense, but then it had a separate count. And in that separate count, in the reckless driving count, it did sufficiently allege the elements and the details. So what does this tell us? What does Howard tell us? It does tell us that an indictment has to either allege the essential elements of the predicate offense or charge the predicate offense completely in the separate account, or somehow in the indictment put the defendant on notice of the predicate offenses by the facts alleged in the indictment compound crime was committed. Okay, so either put it in the top level, the predicate offense, charge the predicate offense, put it in the top level, put it in the compound crime, put it in a totally separate predicate offense charge, or else allege somewhere in the indictment how they are connected, how the predicate offense is connected to the compound crime above. Another case that stands for the proposition that RICO is a special type of compound offense, not simply a more serious grade of forgery, robbery, homicide, or other predicate acts, is the Cotman case, which is the APS case. In that case, Judge Dillard said, this is a compound crime. Okay, so put those two cases together, and that tells us, yes, it's a RICO conspiracy, but you still have to give us sufficient detail of how the conspiracy's, objectives were going to be achieved. What is our relationship to the conspiracy? What is Mr. Smith and the other defendants? What is the relationship to the conspiracy? It's got to be something more than just, you all had the same goal. Maybe you were committing the same acts on certain days. And maybe you had the same objectives. You've got to have that nexus. And that's what we don't have here. The indictment does allege that we functioned as a continuing unit for a common purpose, but never goes on to explain how anybody functioned as a continuing unit, particularly Mr. Smith. It does also in different places in the indictment. It says things like that the criminal conspiracy had the goal to unlawfully change the outcome of the election in favor of Mr. Trump. Okay, that's not a RICO conspiracy. The conspiracy has to be you had an agreement that somebody was going to commit 2 acts of racketeering activity, not 2 crimes. So that's not sufficient to allege a RICO conspiracy in this case. It does have a bare bones 1-sentence allegation that the conspiracy's common plan and purpose was to commit 2 or more acts of racketeering activity in Fulton County and elsewhere. But nowhere does it give sufficient detail as to the connection for Mr. Smith or defendants to the conspiracy's common plan. That's what's missing. The enterprise that's alleged in the indictment, I know that the state says our argument is like, the sky is falling, and that it includes anybody and everybody. Our argument is not that broad, but our argument is that the state hasn't sufficiently cabined the enterprise to fit within a RICO conspiracy, because the indictment alleges that people who were part of the enterprise, which is an association, in fact, enterprise, reaches far beyond just the 19 people named in the indictment. It includes unidentified co-conspirators, people known and unknown, people in Georgia but outside Fulton County, and people across the country. That's too broad to sustain or to pass a special demurrer analysis in this case. We know that there were millions of people who did and perhaps still want or still believe that President Trump won in 2022. There were thousands, maybe even hundreds of thousands of people who took various actions to try and challenge and overturn the results of the election. There were thousands of people who engaged in unlawful activity to accomplish that goal: criminal trespass, disorderly conduct, even more violent actions. Even those people who had the same goal and perhaps took steps that constituted crimes to reach that goal still doesn't mean that they are part of a criminal RICO enterprise. Your Honor, I think I have covered everything that's different or additional to something that you've already heard from us in our briefs. So I will just sit down, and I would like just perhaps a few minutes, if necessary, to respond to Mr. Floyd.
All right. Thank you, Ms. Palmer.
Garner, could we get a opportunity to screen share, please?
All right. What's the host's name?
State of Georgia.
State of Georgia.
Probably should have done that one.
Mr. Derryberry, if we can have the state of Georgia as a co-host.
They're our co-host now.
Thank you. Your Honor, Kimbrough does not control here. I mentioned 1614-2B as the provision that launched 1,000 demurs. Kimbrough is the case that has launched 1,000 demurs. And my friends and the defense are very proud of their win in that case. And that's fine. That's all great. But Kimbrough is not the universal get out of jail free card that they would make it. As you pointed out, the court in Kimbrough said actually said one thing. There's a second one that's a corollary to it. The first was that indictment said absolutely nothing about any relationship between the acts of racketeering activity and the enterprise. It gave 3 examples, federal case law, where the allegations were adequate. The second part is the court said specifically, we are not saying we want pages and pages of detail about these relationships. And that's the bookend on this, okay? And so we're not in a situation, again, where we get this creep that is the state has to allege every single detail, has to tell the defendant what his own motives were, has to tell the defendant everything we have that he did that we think exposes him to liability. No, that's not it at all. And there is no Georgia case that says that. And so we have 2 things going on here. We have a specific argument primarily regarding the Boyle factors, and then we have more general statements about pleading. I'm going to try to jump to the Boyle aspect of it first, but this is really the last argument Ms. Clark-Palmer made. And so that began because the defense clearly recognized they'd overshot the mark in their brief, and so they disclaimed their argument that basically we would, if I recall right, we would have to start converting football stadiums into prisons to incarcerate all the people who are uncovered by this enterprise. No, that's not true. First of all, there's no such number of people charged. And second of all, this is based on a straw man argument. The enterprise in this case does not consist of thousands, hundreds of thousands, or millions of people. It does not consist of everybody who voted for Donald Trump. It does not consist of everybody who supported Donald Trump or everybody who ever asked a question about about the relevant election in 2020. We don't say that. They don't get to rewrite our indictment for us. Okay, another basic principle of Georgia law. It's just not in there. The fact that an indictment says there are persons involved unknown to the state is completely unremarkable and means nothing in this context. Here's the difference. Act 95 in the indictment. Defendant Trump placed a call to Rusty Bowers, an individual who has spoken out a number of times about what happened, the Speaker of the House of Arizona Representatives, in which the indictment alleges Mr. Trump solicited, requested, and importuned Mr. Bowers to unlawfully appoint presidential electors from Arizona, something the indictment says he also did and his Confederates also did in at least half a dozen other states. In that call, Bowers stated to Trump, I voted for you. I worked for you. I campaigned for you. I just won't do anything illegal for you. And therein lies the difference. Bowers did not join a conspiracy to unlawfully overturn the election. Okay? And to say that's not a RICO conspiracy is ridiculous. Okay? The definition of a RICO conspiracy is set forth in Cotman 2. And it basically says a person who knowingly and willfully joins in I'm going to slightly mischaracterize, it's actually in the PowerPoint I'm going to show in a second, basically an endeavor that contemplates committing 2 or more acts of racketeering activity. Not that they have to commit them, not that the acts have to be committed. We've laid this out in our briefs over and over again, citing the United States Supreme Court's decision in Salinas, which makes it abundantly clear you don't have to commit a violation of the substantive offense to commit the conspiracy offense. That's not how conspiracy works. Otherwise, conspiracy would accomplish nothing. Okay? It is enough to insist, to provide assistance. It is not necessary to commit the substantive violation. Therefore, it follows it is not necessary to engage in the acts of racketeering activity. So everything you just heard about not identifying acts of racketeering activity falls out in a conspiracy case because it's not an element. It is relevant at trial. And United States versus Elliott makes this point. While the conspiracy requires that there be some contemplation that acts of racketeering activity will be committed, they are not required. However, of course, if the defendant actually engages in it or his co-conspirators actually engage in racketeering activity, that is certainly evidence of the agreement and entirely relevant. But the fact that it is admissible evidence does not turn it into a pleading requirement in a conspiracy case. Okay? Nobody has been charged with voting for Donald Trump. Nobody has been charged with working on the Donald Trump campaign, soliciting a vote, calling, trying to raise money. None of that. People have been charged because they did something illegal for him or they assisted other people who were doing something illegal for him. The state has identified specific persons in that conspiracy, both the defendants, and has provided the identity of the unindicted co-conspirators. It's made it clear that the enterprise's common purpose was to unlawfully overturn the election results and to do it through a pattern of racketeering activity. The state identified 161 overt acts in furtherance of that and identified relationships between those persons, identifying specifically people who acted together. These people, according to the indictment, and the indictment is read as a whole, and it is read in the light favorable to the state, okay, it shows 2, 3, 4, 5 or more persons acting together. They communicated, and we allege that. They coordinated, and we allege that. They went to meetings together. They traveled together. They talked to each other. They talked to each other about what they were doing in furtherance of the conspiracy. As Boyle observes, the existence of an association, in fact, is oftentimes more readily proven by what it does rather than by an abstract analysis of its structure. And I think that language is clear here. I'll point out that the indictment, since Boyle has been invoked, could you skip to slide 44, please? And as encouraging as that may be, I can't promise I won't go to some of the earlier ones.
I think we're gonna have to move on here shortly, Mr. Floyd.
All
So
right.
I'll give you about 3 or 4 more minutes.
All right, Your Honor, I'm at your pleasure. First, Boyle has not been adopted by the Georgia courts, so it's not Georgia law. But second, if it was, and knowing the possibility that it was, clever little fellows that we are, we studied it carefully and we followed it. Okay? And you heard those 3 requirements that it operate for, and I'm doing these in slightly different order than they're actually stated in Boyle, that it operated for a period of time sufficient to permit its members and associates to pursue its objectives. We specifically allege that on page 15. Okay? And 161 overt acts show nearly 2 years of activity that consisted of a frenetic, coordinated, nationwide pursuit of those objectives. But that's all over the indictment. The defendants and other members had connections and relationships with one another and with the enterprise. We show that. Okay? We allege that expressly, same page. It consisted of an ongoing organization whose members and associates function as a common unit for a common purpose of achieving the objectives of the enterprise. Same page, 15. Boyle is all there, laid out. What they're saying is we didn't plead our evidence in support of it. That's not the requirement. Also, by the way, as to the longevity argument, in Georgia, only 2 acts are necessary to constitute a pattern. Your Honor recognized that in an earlier ruling looking at the binding Georgia Supreme Court case of Dorsey v. State. So establishing a pattern of racketeering activity, were it required, and it is not, is something that happened very early on in this, and they continued to pursue it. Could you take me to one, please? I have a couple of points in these early slides I'd like to make very quickly, if Your Honor will permit. And I'll provide the court with this indictment, with the PowerPoint, and so that you'll see the sites. That way I won't have to go through that. But when we say sufficient information, let's look at what is happening here. First of all, we're not required to plead the evidence. That's clear. I cite Stapleton for that. It is not necessary for the state to spell out in the indictment the evidence on which it relies for conviction. Noticeably, Mr. Smith's argument avoids the actual Georgia RICO cases that talk about the sufficiency of an indictment. The main ones being Grant, which you cited in your October 17th argument, and Pasha itself, a Georgia RICO conspiracy case. They go through this. The indictment clearly gives Pasha notice of the nature of his involvement, the overt acts attributed to him, and the underlying predicate offenses. That's it, all that's required. Grant, the requisite predicate acts and enterprises comprising the charges against appellants are precisely described and named in each instance. No greater detail was required to allege the RICO offense under Georgia law. Those are the controlling cases. When the argument that is being made to some extent, and in the PowerPoint, we go through this, the standard under federal law is exactly the same for the sufficiency of the pleadings, and we provide about a half a dozen examples of federal cases reviewing the sufficiency of indictments, and they don't require any of this. Could you take me to 14, please? And I realize time is coming to an end, and I'll go through this quickly, Your Honor. So the argument you heard is, we don't say anything about the relationship between these defendants. Well, we laid out 161 overt acts. Some of them are committed by an individual. That's the only person acting. An example would be perjury. There's only one person who testifies. A voicemail left. There's only one person on the phone, all right? But there are quite a few where these individuals act together. And when you look at it, these are each on the screen, each examples of overt acts where individuals are acting collectively. They're acting in groups. Trump with Giuliani 5 times. Trump with Meadows 3 times. Trump with Eastman 4 times. With Ellis and with Powell. What happens? How do those people connect? Giuliani connects to Trump, to Meadows, to Eastman, to Powell, to Ellis, to Chesbrough, to Smith, to Cheeley. I have not put all the defendants on here because life is short, but I think these examples are sufficient. Eastman, in turn, as we know, connects to Trump and Giuliani, also to Ellis, also Chesbrough, also to Smith. Smith connects to Giuliani, Eastman, Ellis, Shafer, Cheeley. You notice you're seeing many of the same names over and over again. You're seeing groups of 1, of 2, 3, 4, and 5 people acting together. Those are the relationships that Boyle talks about. They keep doing these things. This isn't them having lunch together. They're not playing fantasy football. These are overt acts in furtherance of this conspiracy. Cheeley breaks the bank. He connects to at least 10 of the defendants in this case. These are all overt acts where they're communicating together, where they're acting together, where they're moving in furtherance of this criminal endeavor. More than sufficient to satisfy any requirement of a common purpose or of a relationship. I'm happy to answer any questions you have, Your Honor, but
All right, if you could email that to us,
it will be done.
appreciate it. All right.
Thank you.
Last thought, Ms. Palmer?
Yeah, last. I think that everything Mr. Floyd just said about what's on it's on page 15 in the indictment, about what they allege as to the enterprise, helps them survive a general demur but not a special demurrer. And that's what our complaint is. I agree with him. They don't have to plead their evidence. I agree that they don't have to plead or prove that 2 predicate acts were actually committed, but you got to give us something. You have got to give us something that tells us what is our connection and relationship with one another. And the last slide that he pulled up that said so-and-so connects to so-and-so, I have this memorized as to Mr. Smith, so he's the one I can speak to. What that means is he's in the same place at the same time. And if we were robbing a bank, okay, that would be problematic because there aren't millions of people or thousands of people who are out there on the same day at the same time in the same place trying to rob a bank. But in 2020 and after, there were thousands of people, maybe even more than that, who were in the same place at the same time, undertaking the same efforts with the same goal vis-a-vis the 2020 election. And that doesn't mean they were in a RICO conspiracy together. One point I want to say just about Grant, because I know the court did cite to that in your previous order in October. Grant was a much more clear-cut, so to speak, case. It's the timber case, right? The indictment alleges an association in fact, but says in the indictment that it was part of the criminal enterprise for the people associated within the enterprise to inflate or deflate the value of timber. I'm skipping over some words just for time's sake. Forging contracts about the timber. It goes on and on. The success of the criminal enterprise depended upon the cooperation of the defendants to move the timber product through their various companies until its origin or final destination was hidden from the true owner. Okay, so that's the information we're asking for. We're asking for the state to tell us give us something about our connection to the enterprise. And it's something more than we were in the same place at the same time on the same day, stating our beliefs. And when they say overt acts, again, as to Mr. Smith, every overt act except one, every overt act matches up to a substantive count. It's just you committed a crime in this place on this day. It's not you made a phone call, you sent a tweet, you sent an email. It's not anything that would address his relationship and connection with the other people alleged in the enterprise. Thank you.
All right. Thank you, Ms. Palmer. So I want to transition over. We had listed out several of the other issues now still pending. I think the thought might be here. Let's, if the folks, we haven't been too boring to the folks on the Zoom call. I think we want to check in with them, see if they're still with us. And I think we would start with the motion to withdraw. And then we can transition over to Mr. Sadow's motion and Mr. Giuliani's motion after maybe a short break for the transition. So with that, I see Mr. Cohen's here. Do we have other counsel? All right. So if we could perhaps make some room at the council's table, we'll move over into the motion to withdraw. And you might want to, like I said, check in with as of now, your client to see if she's still with us. And I can see a box, but I don't know if she's.
Good afternoon, Judge. This is Steve Greenberg. I just don't have my video on because I know we're not supposed to speak on the Zoom, but I just texted her to turn hers back on.
All right. Thank you, Mr. Greenberg.
We're dressed to shovel here in Chicago today.
Good. What? Okay. All right, Miss Cootie, are you with us? I think I still see you muted, ma'am.
I'm here.
All right, great. Can you hear us all right?
I can.
Okay, so Ms. Cutie, just a few things I wanted to take up with you. This shouldn't take more than a minute or two. On December 18th, your current counsel, I think that's Mr. Cohen, Mr. Greenberg, and Mr. Herman, had filed a motion to withdraw from representing you in this case. And in that motion, they said that they have informed you of a few things, including that going forward without counsel can be is usually not a good idea, and encouraged you to obtain new counsel. Did you get a copy of that motion or that notice, or did you have a chance to speak with them about what it would mean when they withdraw?
I haven't spoken to Mr. Cohen at all, but I have received a copy of the notice, and I have spoken to Mr. Greenberg regarding that. Yes.
All right. And we didn't get any kind of an objection to that within, I think it's the 10 days. And so at this point, ma'am, I believe your attorneys would be allowed to withdraw from this case. And so that leaves you without an attorney upon the signing and the filing of that order. So there's a few things I want to go over with you here, and we can kind of get a sense of how we're going to proceed. So obviously, you always have the ability to hire another private counsel. You also have the constitutional right to represent yourself, but that's something you have to do diligently. We can't delay things simply as we wait for you to find alternate counsel. So you also have the right, if you can't afford it, to public representation. And so I guess my first question to you would be, is that something that you're interested in exploring to see whether you qualify for public representation?
No, sir. I will be attempting to retain one of the lawyers that is on this call, and then number two, seek an additional counsel.
Okay, and who would that be? There's someone on the call right now?
Greenberg.
Mr. Greenberg, you're trying to retain him?
Yes.
Okay, I think he's one of the ones who filed the motion to withdraw, though.
Correct. And we've had conversations on attempts to move forward. So in this case, I think he understands particular arrangements that will be made. And I do understand it is his decision at the end of the day, but that is my thought and my approach on this situation.
Your
Okay,
Honor,
so yes, sir.
May I explain, because I don't like talking in circles, and I think I want to make the record clear. So I have known Ms. Cootie for a long time. And when this first came up, even before the indictment, I said I would help her out. And she had the belief that people were going to be able to assist her in meeting what I perceive to be fairly minimal professional obligations, given the scope of the work. And unfortunately, those people did not assist her. So if at some point in the future, she has the ability to have private counsel, I would be willing to assist her. I've gone over the discovery, received all of that. But at this point, given the fact, especially where the prosecutors are saying it's going to be at least a 4-month trial, I just simply can't help her as a friend. And so I think that's what she's referring to.
All right, so you're still pushing forward and would like the court to grant this motion to withdraw, this unobjected to motion to withdraw, Mr. Greenberg?
Yes, Your Honor.
All right, so Ms. Cootie, it sounds like that you have a game plan, is that you still want to see if you can get Mr. Greenberg to sign up, but if not, you've got some other options in mind that you're pursuing. And is that accurate?
That's correct.
Okay, so that's just what I wanted to emphasize, is that I would urge you to continue to seek out that private counsel, not to put this on the back burner. And because I have to caution you that simply if it gets to within a trial date, whenever that is, or another hearing date that's very important to you, if a counsel comes into this case the day before, the week before even a month before and ask for a continuance, that's probably not going to be granted because, again, you have to show that you've exercised reasonable diligence in obtaining private counsel. Does that make sense?
That makes a lot of sense. Yes.
All right. So the idea is I'm probably going to also be bringing you back for a very similar situation in a month or two to check in to see where you are with obtaining private counsel. All right.
Correct. Thank you.
All right. Do you think there's anything else we need to go over today then?
I think not. Thank you so much.
All right. Thanks for joining us. That'll be all. Ms. Goody, thank you.
Thank you.
Okay. And Mr. Cohen, Mr. Greenberg, I'll have that proposed order signed on the docket. Thank you all.
Thank you, Your Honor.
All right. Did we have counsel for Mr. Giuliani with us as well? Yes, sir. All right. As you're coming up and get situated, why don't we take 5? I'll come back, and then Mr. Sadow will kick it off with your motion to compel.
Fine, Your Honor.
All right. I'll be back in 2:45.
Donald Wick. Nice to meet you. You've spoken to a couple of my colleagues, but not me yet.
Okay.
It's good to meet you.
Will you say about the co-defense here?
That way.
Okay. Are we? What I tell. I think we're on the same page. We can't down to. I'd like to have them not bring up the issue of whether they was enforced. Rather than not have a ruling that says. You see what I'm getting at? I'd like.
You have a good holiday?
Yeah.
Exactly.
Kind of hard. That's why I saw it. Over here.
Hey.
Hello. Oh, that's just another. Maybe. Not over. No, I guess. Oh, so they just for shadow. Yeah, shadow. No, it's not. So, yeah, so we're not. Everybody's doing wrong. We're at 4 o'clock. Yeah, so when that happens. When that happens, we shut down this one. Yeah, he's. Yeah, that's fine. Well, I'm gonna make this. Yeah, like the orange. Yeah.
Yeah.
Yeah, the only thing that they're gonna lose, they're gonna lose. Yeah. Out there. Halfway down the hallway, right? Okay.
Extrapolate, yeah, jurisdiction. Basically, someone will hear about federal case and that.
Yeah.
But I think it's.
Okay.
We could really cure.
One might say. Where they were from, where they are.
Cause I was like walking through there, I was like.
Yeah, it sounds like.
Middle court, I was like,
Oh, it's fine.
I'm over here, be less obtrusive.
Going on from the
Say what? I'll get him to identify himself and we'll get to it. Yeah. No, no, that's a lot. Sir. Oh, are you doing this one? This is the motion to compel. Say now. I think that's station.
Oh, actually, that's gonna see.
Yeah, have at it. It's right here. All right, Mr. Sadow, are you with us?
I am, Your Honor. Good afternoon.
Okay, good afternoon. Let's go back on the record. And next up, we have a motion to compel discovery filed by Mr. Sadow on Monday. And Mr. Sadow, I just want to make sure I don't cross my wires here. Is this solely about these videos, or has this now expanded to be something? You know, there's been a flurry of emails here. Is this broadened? What is it that you're seeking to compel?
I'm specifically seeking to compel at this point material that may have been shared by the J6 committee with the district attorney's office, for which the district attorney's office apparently was not permitted to maintain or preserve or keep, but was able to view what appears to be April 18th through 21st of 2022.
All right, so you're not asking for correspondence like I think Mr. Clark just filed a motion. Is that right?
Well, I had asked originally, let me see if I can preface it in this sense. The motion to compel asked for the response of the J6 committee or the former chairman Thompson to Ms. Willis's letter, which is attached to the motion to compel, in which he asked for videos and other material which would help further the district attorney's investigation. I also became aware that there was a video presentation made to the special grand jury as to two Department of Justice officials, Mr. Rosen and Mr. Donahue. I included that in the motion to compel, as the emails going back and forth over the last couple of days indicate. I asked for it simply whether it had been turned over in discovery. I asked for it 3 separate occasions. The district attorney's office, in its infinite wisdom, chose not to respond to those email requests. And then after I filed the motion to compel, which of course took a little time to put together, decided that they would say, yes, it's in the discovery. So to the extent that it's in the discovery, that part of the motion to compel is no longer before the court. Although I must say, I find it somewhat troublesome, trying to keep it at the base level, that I would be forced to file a motion to compel for the DA's office to respond by saying yes. It doesn't seem to make a whole lot of sense. And under those circumstances, I'm sorry if that's wasted the court's time at all. That's not my intention. So we move back to the response that I had sought from the J6 committee and former Chairman Thompson. The DA's office refuses to turn that over. It wasn't until Monday, when another motion was filed by defendant Roman, that I was able to access invoices which indicated that, in fact, the J6, some members of the J6 group, I don't know whether they are the actual committee members or people or staff, met with Mr. Wade and apparently another prosecutor, as well as investigators from the Fulton County District Attorney's Office. And as I said, the invoice in my supplement indicates that that initial meeting appears to have occurred sometime from April the 18th to April the 21st of 2022. So what I won't call it expanding, but what I'm trying to do is find out what it is that the J6 committee allowed the DA's office to get access to. I'm assuming everything that the DA's office actually received, a physical document, they've turned over to us. I'm not suggesting that they are in some form or fashion not fulfilling their discovery obligations. The concern I have, and which is also represented now in the Politico story that I have sent along as part of another email, that appears that they were given the right to review material for the J6 when they were there, but weren't permitted to keep it. I don't know what they reviewed. I don't know whether what they reviewed hasn't been turned over to us, but I'm trying to find a mechanism to determine if there is information that the district attorney's office had access to under restrictions that we ought to be able to gain access to, because it may be material to the preparation of our defense. Is it technically within 1716.4? No. Could it be within 1716.7 if it relates to witness testimony? Yes. But I've also cited to the court, and the court has certain inherent power to grant us, under the circumstances of this particular case, in the interaction between the J6 committee, which obviously is the U.S. Congress, and the district attorney's office, so we have federal and state involvement, a means by which we can determine if there is material, as I said before, that the district attorney, particularly Mr. Wade and his investigators, were allowed to look at, but not allowed to actually obtain or receive. That's the thrust of this motion to compel. I'm not suggesting that there's been any wrongdoing. I'm not This is not a J6 shouldn't have shared with DA or vice versa. This is just trying to get to the basic notion of what it is that may be out there that was shown to the DA's office that they don't have for any reason, and therefore we can't put our hands on. And to make it one more step forward, we know through our investigation, and that includes information that I have received from defense team members for President Trump in the DC case, that there has been the destruction of evidence by J6 committee, including videos of interviews and potentially deposition testimony. None of those, there are no such videos of that type that's in the DA's disclosure or production here. There is videos which I've now been pointed to that were done publicly. I'm not talking about that. I'm talking about what would be private interviews or private depositions. So I don't know whether the DA's office had access, viewed those, compared notes of investigators, but that's the thrust of where I'm coming from.
All right, let's see if we can narrow it in and focus it just to see exactly where we are. So, Ms. Young, let me start with
And it
a
seems
few of
to,
these.
now that Mr. Sadal has kind of clarified what his request, and I'm assuming that's separate from the motion that Attorney McDougal may have filed, because it's a little bit different than what was actually posed to the state originally. So what I heard Mr. Sadal say at the end of his request is that he's asking for anything that was private, that was shared with the DA's office during this meeting that was had by Mr. Wade and Mr. Wakeford. I just want to make sure before I answer that question that that is what he's asking for, so I can answer it accurately.
Right. So
May I respond?
Sure, Mr. Sadao.
Yeah, and because I don't want to make this any more difficult than it may already be. I am aware for certain of the 418 to 421. I know there were phone calls thereafter. I don't have any evidence that other information was shared of a material nature, that is physical nature. So that's why I have focused on the mid-April activity. But yes, I also am still seeking the response, if there was one, or there is some, from the J6 committee. And I'll just, so that the court remembers, the DA's office sent around to counsel on September 27th of 2023, something that they called their open file policy, which basically is, if it wasn't privileged, it's not work product, have at it. We'll show it to you. That's where I'm coming from. So yeah.
Right. And so when you say the word response, it's not potentially, let's say, an email from the committee saying, how are things and whatever else. It's actual documentary evidence that may have been turned over. Is that fair?
It's fair to say, if you look at the exhibit to the motion to compel, exhibit number 1, that is the one that was filed on January the 8th. That's District Attorney Willis's letter to Honorable Benny Thompson, in which she asked for recordings, transcripts of witnesses, interviews, depositions, electronic and print records of communications, and records of travel. I wanted to find out if the chairman responded by saying, we will give you access to such and such. Let's make arrangements for you to see such and such. That's what I was looking for in the response. If his response back was, thank you for your letter, we'll be in touch.
Sure.
That
So I
would
think
be
there's
easy enough
two
for them
parts.
just to tell me.
I think there's two parts we got to flesh out here. So I think the first question to the state would be, is there anything actual physically that you were provided that has not been turned over to the defense that was given to you by this committee?
And the state's answer is no, Your Honor. The state has repeatedly said that we have turned over all exculpatory evidence that we have received to all defense counsels on multiple occasions. There is nothing that we received from Jan 6 that has not been turned over to all defense attorneys. And the state will also say everything that we turned over are all things that were publicly out there. And we actually got it from a public website. It wasn't even actually something that was sent to us by the Jan 6 committee. We downloaded it from the public site in which the Jan 6 committee had put everything out that was handled during that committee session.
All right. So that would be their answer to part 1. Part 2 then, which is a little more legally uncertain in my mind is, were you allowed in the room with other documents or exhibits or what could be characterized as evidence, allowed to look at them, watch them over and over, and then leave with just whatever is in your head or your notes?
And Mr. Wade is going to answer that question, Judge, since he was the one that was present and not I.
All right.
So, Judge, I think that I could provide some insight to both of the last two portions, which would be the response letter portion of Mr. Sadow's motion, and then the evidentiary portion that the court is inquiring. Firstly, DA Willis did send over a letter to Chairman Thompson requesting certain things. The tone of Mr. Sadow's letter led us to believe that, okay, perhaps we are missing something and we didn't provide something in discovery. So the time period that elapsed was due to our elaborate search to make certain that we didn't fail to provide or turn over something that was in existence. Even as late as last evening, we reached out to Chairman Thompson to make certain that he didn't send over a response and we just missed it or didn't receive it. So the answer is no, we never received a response, a written response from Chairman Thompson. Does not exist. And the only reason for the time lapse is because we wanted to search, and double search to make certain that our response was an accurate one. As it relates to travel to DC, Chairman Thompson shared with us during this conversation regarding the letter that his directives were that we were allowed, we being the district attorney's team, would be allowed to have a conversation with his investigative team. We were not to share any information. We were not to exchange any information. We could have a conversation. If there was something that we wanted to show them, we were allowed to do it. If they wanted to show us something, we were allowed to have a look at it. But there were no photocopies of anything, and there was no sharing of tangible documents of any kind.
Would you agree, though, that let's say if this investigator had told you something that completely contradicted a statement that you'd received from a material witness that you'd already turned over to the defense, that you would then have to document that in some way or turn it over as part of a Brady obligation?
I believe that, yes, sir.
All right. And are there any concerns here from what you spoke to with these investigators reaching that level?
Absolutely not, Judge. In fact, everything that was shared in that conversation was made publicly available through the Jan 6 committee when they released all of their documents. So everything that we talked about, everything that they shared was publicly released.
All right. So, Mr. Sadow, turning back, as I hear the response to part one, it's that they never got any kind of a formal written response from the chairman for them to disclose to you. And then on part two, yes, they did have a meeting and they spoke to investigators and they maybe shared notes in the metaphorical sense, but they don't have anything physical in addition to what's already been turned over to you. Any reactions to that?
Well, I take them at their word that there was no response. It would have been fine. Might have made this whole proceeding a bit easier if they had simply said in response to the several times that I had asked, we're looking for it, we'll let you know, as opposed to no response at all, or we're not going to respond to you at all. But the other part of this is, it appears that there was a extended communication conference in which information was shared. Now, Mr. Wade has not indicated whether or not they actually gave him documents or materials that they could review as opposed to just communications or conversations. So I'd like to know that. And to the extent that Your Honor has already hit on it as to whether or not there may be exculpatory evidence or otherwise potentially inconsistent Giglio type evidence.
All right.
My question would be, were there notes taken by their investigators, the DA's office investigators, and or by the attorneys that are still in existence that could be supplied to the court for an in-camera examination to determine whether or not there is anything that the court would deem to be potentially disclosable under either its inherent power, which I've mentioned, or under due process considerations, exculpatory evidence Brady Giglio. So that's my follow-up.
All right, a lot to unpack there, but I'll just turn it back over to Mr. Wade at face value.
Again, Judge, everything that was shared was released publicly through the Jan 6 committee. We don't have anything that they hadn't released publicly. There were no notes taken that we would need to turn over or that has something in it other than what was publicly released. Our investigator hadn't.
Just to be clear, you're not claiming you didn't take notes, as I would think most lawyers would, but the idea is that you have notes and you believe those are work product.
Yes.
And you've reviewed those notes, and as of now, as the evidence stands, you don't see anything rising to the level of Brady material.
Nothing at all.
All right.
If I may, just the first point that Mr. Sadow made in regards to the state answering yes or no to his question. The state still stands firm on the state's not required to answer yes or no in regards to whether or not they received a letter from Mr. Thompson. What
You're
the
not
state is
required to, but doesn't make the issue go away, right?
No, Judge, but the state is fully aware that if we did receive information and documents, that we should turn them over, and we have turned over what is public out there. So I just want I want the court to be clear that the state was not just not answering a question for Mr. Sadow. The way that it was posed is though they were looking for a communication attorney work product, which they're not entitled to. And that is why the state did not respond as Mr. Sadow wanted the state to respond. We responded that yes, you have all evidence that you're entitled to through the discovery statute, through Brady, and any exculpatory evidence that may be in the state's possession. All of those things have been turned over.
All right. And Mr. Sadow, I think I take your point. I understand where we are. I don't think we need to dwell on this too extensively because unless it starts flaring up again and again. But
no, and I understand that, Your Honor, and I appreciate that. These kind of disputes, so to speak, do not need the court to waste its time dealing with. That's something that counsel should be able to handle. If I may ask one other question, were the investigators from the DA's office or the attorneys, when they were in conference or when they were with the J6 committee or members of the committee or their staff, were they permitted to view any videos that have not been made public?
The answer is no, Judge.
All right. All right, Mr. Sadow, if you ever receive any other indication that that is not the case, you can renew your motion and take it up at that time. However, at this point, based on what's been alleged in the original motion, it seems like that is moot as to the videos presented to the grand jury, and as to the supplemental part, it seems like those concerns have been addressed with the caveat of could have been done in an email, perhaps, but we'll see.
Perhaps.
All right. So anything else, Mr. Sadow, then?
Yes, Your Honor. I was told via email that all the lawyers were told via email that you would briefly discuss the notion of adopting co-defendants' motions. Specifically, I had asked in reference to the motion to dismiss and disqualify filed by defendant Roman's counsel on January 8th of 2024. I had sent an email along asking for leave to adopt at a later time. Does the court want to take that up now, or do you want to take that up at the end?
No, I think we can address that now. So I'm remembering that the just kind of addressing the adopted motions, because they've gone every which way here to try and impose some sense of order on this, is that the conclusion had been you can adopt a motion, but that doesn't necessarily entitle you to argument on it. But then I recognize when you have a drop dead motions deadline, you don't necessarily have time to adopt your co-defendants because they just got filed simultaneously. So in essence, are you asking just to adopt it on its face, or are you looking to supplement it and go much further than where it already is?
Well,
or
actually,
essentially
neither one.
to join counsel at the table.
Well, actually, neither one at this point. This is the first motion in which there have been allegations of fact made, which deal directly with our opposition counsel. Suffice it to say that they are salacious and scandalous in nature, And I don't have a factual background that I can state to the court supports that at this point. I'm leery of moving to adopt motions that make such allegations without having a better understanding or substantiation of the allegations. What I'm trying to do here, it's one thing to adopt a motion that brings up a matter of law. This is different. I was hoping the court would give me the opportunity when the DA's office responds to that motion to see what the factual disputes are, what the allegations, whether they are disputed otherwise or whether they are supported, to give me the opportunity within a few days of that response by the DA's office to make the determination whether I wish to adopt. That's specifically what I was hoping to accomplish with regard to that specific motion. Otherwise, I should be able to adopt motions right away like I did. There were certain things that were filed on January the 8th by co-defendant counsel, and I immediately adopted those on January the 9th. But this is different. That's why I put it to the court as I have.
All right. So obviously my plan with this was to allow the state an opportunity to respond before setting a hearing date. And as for the date of a hearing, we have to work around the other trial calendars in this docket. So I think early February would be the soonest that would happen. And so I think that would give you some time, Mr. Sadow, to consider any adoption if you need to. Again, I'm not opposed to just merely adopting it to preserve the issues if that's something you do want to join. So to that end, I would say you do have some leeway there, but at the moment when we've got a response from both sides and we're ready to set it for a hearing, what I'm trying to avoid is dragging it out because other parties want to piggyback and do their own separate investigation, if you will. There's a motions deadline and we're trying to stick to it. Am I making sense?
I understand that, Your Honor.
All right.
Yes, totally. All I'd ask for then is if you'll give me 2 days to adopt after the response. I need no additional time after that.
All right.
May I just briefly address that?
Sure. And
Craig Gillen.
Mr. Gillen, for the record.
Shafer. Our motions are due February the 5th.
Right.
Now, we are looking at that motion which has been filed. We're going to do our own investigation and determine whether or not we're going to adopt that motion or supplement that motion. Just want you to know that that's what our timetable is.
All right. Understood.
Thank
you. Does the state want to add anything?
Not this time, Your Honor.
All right. Anything else, Mr. Sadow?
No, I take it the court will give me at least a couple of days after the response. I'll get it in immediately.
All right. Yeah, like I mentioned, I don't know when the state is planning to file a response, but at some point we will have to set it for a hearing. And right now, again, like I said, just based on the schedule, we're targeting early to mid-February. So I would imagine if there's going to be a response, it would be before that time. All right. If that is all, Mr. Sadow, I think we're going to turn to Mr. Giuliani, and unless you're free to stay on if you want to.
Thank you, Your Honor.
Okay. So if we could have counsel for the record, your first appearance for the record here.
Alan Stockton for Mayor Giuliani, and John Esposito and David Lewis, I think, are attending virtually, and I think the mayor may be watching on YouTube.
Okay. All right. Well, welcome, Mr. Stockton. I saw two motions pending that we could take up today and address. I wonder if we could start. One of them seemed a bit more straightforward than the other. So your motion asks for interviews with the co-defendants who have already pleaded guilty. As I understood it, there was nothing prohibiting that, especially from counsel. If you need clarification on that, we can give it. But your motion goes a step further and says you want to compel interviews. And I think we've got some clear case law in Georgia that says I can't do that.
Judge, I think we can take this out of your hands for the time being.
I'm welcome to hear
We've
that.
been talking with the state, and on this issue anyway, we've agreed that the issue of whether or not they could be compelled will be reserved. I think there is some law that would if the court saw it our way, that you could justify compelling them to discuss the case with us. But what the state and Mayor Giuliani's team have agreed to is that we would just put that issue, just put a pin in that and wait. We believe that we'll probably be able to talk with these people. The only issue we're dealing with, yes. The only issue we really have is the state is wanting to either be present or have recorded any interaction we have with these co-defendants that have already pled. Judge, my understanding, there's a case, Shields versus State. It's the closest thing I found. And basically that's 264 Georgia Appeals 232. And basically what that just kind of provides in the periphery is that if we were wanting to speak to one of these co-defendants and they would refuse to speak to us without the state being present, that's that defendant's or that witness's prerogative. But otherwise, we would submit it. It wouldn't be proper for the state to be part of our investigation, just like we weren't part of theirs. We weren't there when the proffer videos were made. We didn't get to be a part of that. But that's the only issue I believe we've got on this is whether or not the state is entitled to be present and or record or have a recording of that.
Well, I think we end up coming full circle then. I don't know if we can kind of neatly avoid the main issue, which is my understanding from the stretching back from the Georgia Supreme Court was the state can't deny you access to a witness and they shouldn't be instructing their witnesses not to talk to you, but that the ultimate decision rests with the witness themselves. So if they, and that the witness can set any conditions or preconditions that they want.
Correct.
So if any of these folks want the state to be there,
and that's not our issue.
I think they have to be.
Yeah, no, that's not our issue. Our issue is the state is saying they want to be there.
Sure.
And we don't want the state to be there unless the witness requires it.
Sure. That's my understanding of how it works and the state of the law, but I'm willing to hear if otherwise.
Well, that's all I have from our position on that.
Okay, let's see where we are.
Alex Bryant for the state. Very briefly, we do insist on that condition of either the state being there or having these videos recorded. Mainly we have probation conditions and we have bond conditions, and they're there for a reason. There's make sure that there's no harassment, no influencing the witnesses, no intimidation going on. And these are measures that would be able to remedy and be protective of those purposes and still be in line, in conformity with those probation conditions and why they were imposed. As to the video recording, I think there's a second purpose in that, and that there's an efficiency purpose. Once they're recorded, we've got 15 defendants. You know, we don't want to have to subject these witnesses over and over again to interviews, and especially have to repeat themselves over and over again to each defendant. So I think a video recording helps alleviate those concerns, and also to help alleviate our concerns that they were being in undue influence or intimidation, because they know that it would be video recorded and be turned over to the state.
I think it's, you know, what you're proposing may be the most efficient thing, and it's certainly not completely unreasonable, but I'm wondering if this is just a kind of the necessary baggage of having a multi-co-defendant case. You know, based on the nature of the questions a defense counsel might ask a witness, they could consider that as revealing their strategy or where their focus is going to be, and saying that one interview is going to be able to satisfy every single other co-counsels may be a bit too optimistic as well. Everyone might need to be going down a different road. So I mean, I can see the point. I don't think that's going to be one that we're going to be able to satisfy there.
Also, don't think we need an order yet, because there's been no discovery violation at this point. We've turned over the proffer recordings, we've made available these witnesses, we've given their contact information, and there's been as to these probation conditions. There's been no threats that we revoke probation,
Sure.
excuse me.
Right. And to the state's other point of, well, we have these conditions of probation and we need to make sure they're not violating them. That's a fair point, but there has to be some kind of limiting principle. The state didn't ask as a condition of probation that they're monitoring all conversations of any of these defendants who have pleaded. And I suppose there's a heightened risk, if you will, when you're dealing with a co-counsel, but I think there always has to be some level of professionalism and trust involved when we're dealing with officers of the court. So let me ask Mr. Stockton, is this something Mr. Giuliani was planning to be sitting right there in the room as you interviewed these people?
No, not at all, Judge. He unless there is an apartment in New York, he's not coming down here to interview or where these people reside at the time. Judge, and I don't think I've completely hit on this, but the main reason to file this is in the colloquy, and when you were announcing your sentence, one of the things you said was, and this was just on defendant Jenna Ellis, she's not to have any contact either personally or through other agents.
Sure.
I don't think this is what the court meant, but at the same time, I can see somebody that's wanting to comply with the letter of this that might need some clarification from this court that it is okay for them to discuss this with not the defendants themselves, but with the defendants' representatives.
All right. Well, just again, anticipating that this may be a concern with other co-defendants as well, I think it's worth, I'll file a brief kind of order and response. Again, I think I need to reiterate that the black letter law here is that a witness can't be compelled to speak with defense counsel. If you want to raise that by later down the road, if we know they are, and you think you have case law in the alternative, we can take a look at that. But essentially, a witness can't be compelled to have an interview. The witness gets to set the conditions. If they want the state there, I think the state gets to be there. If they don't want the state there, I think they get to speak with you privately. And they're pretty much the ones in control at that point. There weren't any other conditions as part of their sentencing that proved otherwise, right? All right. Is there anything else then we think we should clarify there or needs to be addressed?
No, Your Honor.
So then we move on to Mr. Giuliani's more substantive motion.
Respectfully, Judge, I think we can handle this even quicker.
Okay. I remain cautiously optimistic.
Judge, this was filed by Mayor Giuliani's prior counsel on September the 8th of 23. Shortly thereafter, they withdrew from the case. The court set down motions hearings on pretty much everything except this one, so the state hadn't responded at that point. I filed a motion for a hearing on this, and very quickly the court set down this date, and the state has not had an opportunity to respond yet. In talking with the prosecution, Judge, what we've discussed, if it pleases the court, to begin with, a lot of this has already been taken care of in argument. You'd just be hearing redundancy. But there are three areas that I don't believe have been addressed, and all three of those areas deal with the overt acts that occurred in other states.
Sure.
And one of them had to do with equal protection. One of them had to do with Brady issues, and the other had to do with jurisdiction. In talking with the state, they were going to, if it pleases the court, no argument today, them present their side of it in writing to the court, and then maybe give me, if I need to respond, another 10 days or so to take care of that.
All right. And then we just handle it through the briefing?
Yes, Judge.
All right. And just by way of kind of focusing in the briefing, Mr. Stockton, on the equal protection issue, just when I was kind of making a preliminary look through it, I want to make sure I understand the argument. It's that, is the concern simply other states could prosecute your client for the same predicate act?
Yes, Judge. And for instance, arguably Georgia, you can't be sentenced for the RICO and the predicate act, but in Florida you can. There's just
Sure.
Georgia.
But how does that become a double jeopardy issue if all the states are separate sovereigns? I mean, couldn't he be convicted in every single state, all 50 states, if there was an issue without any double jeopardy concerns whatsoever.
You may have a point, Judge. I mean, there may be something to that, but
All right, well, that's something to focus on in briefing then.
thanks, Judge.
All right. Okay, then, we'll take that up on the papers. I guess since we are all here together still, I can open it up to general housekeeping for everyone who's still here and with us.
Certainly, Your Honor. Catherine
Okay.
Bernard here for Jeffrey Clark. And
got
we
it.
had adopted President Trump's motion to compel, and it looks like the court has ruled on those issues at this point that, the representations of the district attorney's office that they have not been given access to any classified or private information that is not publicly available, but that the court is willing to revisit that ruling should any additional information become available.
Sure.
We understand that correctly. And we did also, there has been quite a bit of communication back and forth via email between the district attorney's office. And so out of an abundance of caution, the district attorney's office had included some of our previous requests specifically for communication based on TUI regulations and whether or not TUI letters had been received for Mr. Rosen and Mr. Donahue. And so we did, out of an abundance of caution, flesh that out into a new motion to compel, simply filed on behalf of Mr. Clark. And we are prepared to take that up today. And I do have copies for the state. But of course, if the court would prefer to hear that at a separate time, we are available.
Right. So I think you filed that today. I was able to read it, but obviously we didn't notice it for today. So if the state's not ready to hear it, then I think we need to give them an opportunity to, digest that and respond. But perhaps we could at least make sure we understand and we're focused on the issues at hand. Well, actually, first, let me just ask the state if they want to take it up today in the spirit of efficiency.
Judge, we appreciate that, and the state, of course, it's of course willing to give us time. We will take all the time that the court's willing to give us.
Okay. How much time do you need?
We can hear whenever we set for the next, since we're talking about moving forward, the next hearing date that the court said. I would just say maybe not next Friday. It seemed very jam-packed, but maybe the next hearing after that.
All right. And Ms. Bernard, I just want to, again, to focus the issues. That motion, we're honing in on the actual communications between counsel and the committee or the White House, right? It's not so much what Mr. Sadow was getting at in his motion to compel about what other evidence, documentary or otherwise, came as a result. You're looking for the actual communications that have occurred between the two entities, right?
Yes, Your Honor, particularly if there is anything in response to the request for a TUI letter that we believe was made for both Mr. Rosen and Mr. Donahue. It has been reported. We included as an exhibit to our filing some of the media reporting that indicated that that request had been rejected. And we do believe that that would be material and relevant to Mr. Clark's defense.
As a defense of?
And Your Honor, at this point, we believe that it would be material and relevant, particularly if Mr. Rosen and Mr. Donahue, who are the main witnesses who we believe they are prepared to provide evidence against Mr. Clark. That is the case with his ongoing proceedings within the District of Columbia. And so we believe that if they are not going to be available as witnesses, that will be a tremendous, that will be a tremendously important element of the case going forward.
Right. So if an investigator is out there trying to put a subpoena in a witness's hands and they just can't find them, is that something that you also think falls under Brady?
Potentially, yes. I don't know that that would be the analogous situation here, since it does involve intragovernmental communications, particularly with the individuals who potentially are responsible for initially leaking the draft letter that was in late January of 2021. So again, we're looking for the information. We're looking for at least a response from the district attorney's office as to whether or not they received anything back from the Department of Justice in response to that request.
Right. So I'll just give you my initial reaction as a preview to, as the state gets its response in the hearing, is that I think the first aspect of it, it seemed you were raising concerns or kind of building an argument about selective prosecution, right? And that has more of a legal hook, if you will. But the latter half of it was talking more about, just to boil it down, hey, we need a heads up of who could actually be able to walk through the courtroom and present evidence. That was a kind of a more novel theory to me. So if you've got something else that kind of connects those dots, I'd be welcome to hear it. But that by itself seemed like a bit of a stretch. So we'll take it up at the hearing and open the floor back up. I don't know who is still with us at this point, or if there's anything else to address, or if it's kind of petered out or where we are. But anything else? Okay, then we will stand adjourned and we'll see you next Friday.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.